Well, Lady, I was dealing with the last of the issues on my appeal, the issue of the scope of List C item 22.
Yes.
And I'd shown you how the first tier addressed that question and shown you the paragraphs in the upper tribunal. In our submission, it is clear that when the upper tribunal dismissed our appeal against the conclusions of the first tier, it was confusing the submissions that we were in fact making with the issue in SSE about the difference between creation in situ and installation. So it has in effect answered a different question. My friend Skeleton attempts to invite you to draw a different conclusion, saying that on a fair reading, the upper tribunal was actually concerned with the right question. But in our submission, there's nothing in paragraph 145 in the upper tribunal that makes that clear. So our complaint here, in effect, is that the first tier was wrong to reject our original case about the scope of C22 and how it might apply here, and the upper tribunal have not adequately addressed that complaint because they have dismissed us for a different and here unrelated reason. Now, standing back from C22, thinking about the alteration of land in the sense that we say is clear from the 2001 legislation, if you turn earth on a greenfield site to pour the first concrete, let's assume you thereby make a slab, and it's the slab to one of the facilities. That slab is going to have a seismic purpose or function, and we say that can be a plant function in this trade, and indeed is. You then pour more concrete to create integrated walls, shield walls, and they play the functions of seismic qualification, radiation shielding and attenuation, and or dealing with chemical hazards. Again, those can be, here we say, are plant functions in this trade. The first tier also found that those items, both the slabs and the internal integrated walls, played other vital functions in relation to these facilities, so either supporting or holding or stabilizing kit that was necessary to deconvert the tails. And then we go one step further and we put a radiation shield on top. You may recall this discussion in the first-tier tribunal of this concept of sky shine. So radiation can escape out into the atmosphere and then rebound back to Earth by shining off the cloud base. We put a radiation shield top on these facilities. Now, does calling it a roof mean it's a building? We say no, that's a separate debate. But thinking about C22, can some or all of that expenditure amount to expenditure on the alteration of land as properly understood, only for the purpose of installing the kit inside the facilities? And we say the answer to that is yes. So where does that lead if you were against us on section 21 and building, so that it became necessary to look at list C, and I put to one side here the debate about C1 and C4, but you come to the conclusion that it is necessary to address the scope of C22, then in our submission the only sensible course would be to include that issue on any remitter to the first-tier tribunal, for it to consider, with the benefit of the guidance of this court, whether the requirements of C22 are in fact met. So that's where we say it leads. And that's all I would propose to say about C22 in opening. Unless there's any part of that debate I can help you on further with at this stage.
Thank you.
And that means that even on my learned friend's preferred timetable, I'm a little ahead of time. So might I ask him through you that if need be, I can have some time and reply to his case on this.
Thank you, Mr. Peacock. Mr. Brennan.
I'm obliged, the lady. Can I start, please, with the points in reply on my appeal, and then I'll turn separately to the response on the cross-appeal on List C items 1 and 4 and item 22. I'll take each of the three grounds in turn, if I may. So on ground 1, I can deal with this quite shortly. I just need to address in reply the pleading point that my learned friend sought to bring up yesterday. He tried to say there was no ground of appeal covering my point on the building issue, that even if the upper tribunal was right that there had been an error of law by the first tier, the upper tribunal should not have set aside the first tier's decision. It was said that wasn't open to me in this court. And I simply address this to say it is a bad point, and I'll just make that good very quickly by showing you what the ground of appeal actually is. It's my ground 1, which is in the core bundle. Tab 1, and it's page 14. And the ground is that the upper tribunal erred in law in setting aside the first tier's decision. Now, plainly, that allows me to argue that if there was an error of law diagnosed by the upper tribunal, that error of law was not material, so that the first tier decision should not have been set aside. And that's precisely the point I'm making, among, of course, other points, because my core point on ground 1 is there was no error of law at all. But the ground of appeal that I have, and which I have permission for, certainly encompasses the argument that I'm making, and the suggestion otherwise is just wrong. It's also clearly, it's also clearly a point that I have permission to run, permission that I secured from the upper tribunal. I'll just show the court that very quickly. That's in the application for permission to appeal, core bundle tab 14. Bad reference. Okay, yes, sorry, I've given myself a bad reference. It's in 2 places. It was 14, but I was looking at the wrong paragraph. It's paragraph 16 within that document, bundle page 206. So you see, even if correct to diagnose errors of law, wrong to set aside. And just to complete the chain, I get permission on all grounds. And just for your note, that's in tab 13, page 198, paragraph 4. Exactly the same points made in our skeleton in this court, paragraphs 52 and 53. So there's absolutely nothing in the point that there's some procedural obstacle to the points that I'm making to this court on ground 1. I don't need to add anything by way of reply to the substantive submissions on ground 1 I made in opening. I simply say that nothing that was said in response justifies the upper tribunal's conclusion that there was an error of law in this court, has my submission that it was perfectly permissible for the first tier, as it did, to take into account both characteristics and function. I say that approach was perfectly conventional and indeed right. On ground 2, on my appeal, so that's plant premises, I have 3 points. The first is that my learned friend characterised his complaint about the first tier's conclusion on the plant premises issue as an error of characterisation. That was what he said at about 11:05 this morning. Now, that is simply not a correct way of describing what the first tier did. The reason it's not correct is that at no point did the first tier find that the functions of shielding and containment, etc., that my learned friend was relying upon are necessarily premises functions. My learned friend said that such a conclusion was baked in, was the way he put it, to paragraph 99 of the first tier's decision. That just isn't right. What the first tier was doing was looking at the particular facts of this case, and it was saying on these particular facts, that is what the nature of these functions are. So that was an evaluative conclusion. It wasn't the result of some sort of a priori classification or assumption about what those functions had to be. Exactly the same point arises in relation to the submission that Mellor friend made about the active-passive distinction. Your ladyship will recall that the point, going all the way back to Gerald and John Good, plant can function passively. No difficulty as to that at all. But again, in this case, the first tier did not say that there had, as a matter of law, to be active functions in order for the items in question to be characterized as plant. What happened was that the first tier rejected the argument that the shielding, containment, seismic qualification functions were functions of plant. That was what we saw at paragraph 95. That was a finding on the facts of this case. What it then did, and again, this is perfectly conventional, is it said, well, okay, what else over and above those functions is there that may lead to the conclusion that the items in question are functioning as apparatus and therefore to be characterized as plant. So what Mellor friend is doing when he talks about error of classification here is he's ignoring the point that the same function may be performed either through plant or through premises. And as we saw in opening, the basis for the upper tribunal overturning the conclusion of the first tier on the plant premises issue was the upper tribunal's criticism of paragraph 95 of the decision. And Mellor friend has simply not answered my complaint that plainly the first tier was right to hold that whether something is required by regulation does not inform whether the item is functioning as plant or as premises. Suppose the regulations had said you are required to conduct particularly marvellous buildings. It just simply doesn't bear on that question. The first tier was absolutely right to look at the trade functions as they actually were and the functions actually performed by the items in question. And that is why the criticism of the first tier's conclusions, especially in that paragraph, paragraph 95, which we spent a lot of time on in front of the upper tribunal, why that is ill-founded. Point 2, in relation to ground 2, is in relation to Wangaratta, the Australian case. Mellor friend tried to draw a parallel between the present case and the judgment of the High Court of Australia in Wangaratta. I simply say Wangaratta is a decision on its facts. The process in that case was different. The role of the assets was different. And in this area, what we are not engaged in is an exercise in fact matching. And you can see that in particular from this court's decision in Cheshire Cavity, looking at the cases where it is said that numerous cases were capable of decision either way. So what the first tier needed to do in this case was look at the facts of this case, apply the relevant principles to this case, and I say, having done that, the first tier was fully entitled to distinguish Wangaratta in the way that it did, and again, that's paragraph 95 of its decision. It rightly noted the differing nature both of the process and also of the role of the assets in that case. Third point in relation to ground 2 is, again, to deal with a pleading point. It's also a bad pleading point. This is about the scope of any remitter, because you'll recall in opening I'd said, well, suppose I don't get home on satisfying you that the upper tribunal was wrong to diagnose an error of law. If there's to be a remitter, the upper tribunal actually hasn't dealt with the point that we made, that you should look at all of these assets as a whole. And I'd simply show you that this is a point that we secured permission from the upper tribunal to appeal in relation to. So this is in the application core bundle tab 14. and bundle page 210, it's paragraph 24, that's exactly this point. And just for your note, the grant of permission, that's the reference I've already given the court, it's paragraph 4 at bundle page 198. And so this is, in my submission, clearly covered by ground 2. And the point, equally, is explained and set out in terms in our skeleton argument, served at the same time as the grounds, or at about the same time as the grounds, paragraph 65, bundle page 39.
Mr. Premier, I think you said paragraph 24 of the application.
Yes.
But I think is it not paragraph 25 that is dealing with the remitter question? I mean, paragraph 24 is the previous point.
Your Lordship's quite right, I'm very sorry. 25 deals expressly with the remitter question. I think I may have said the wrong number. I did say 24. Your Lordship's quite right. I'm sorry, it's 25.
Yeah.
But the point I was trying to make, or I got the number wrong, the point is a good one, which is that I sought permission on exactly what I'm asking this court to do. I got it. It's in the skeleton. On any fair reading of the grounds of appeal, it's covered. And I just say in parentheses, it's a bit rich to have the objection made for the first time this morning. The point's not even mentioned in Learner Friend's skeleton. But it doesn't matter because the point's a bad one anyway. Ground 3, I can deal with very briefly. The nub of Learner Friend's response this morning, this was dealing with on the provision of issue in relation to the walls and slab in the vaporisation facility. He tried to suggest that the first year hadn't asked itself the right question. Now that point simply cannot get off the ground, because if you look at the conclusion that the first tier reached, and we've looked at this already, it's paragraph 98 sub 5, bundle page 242. There's an express finding that the facility is part of the setting. And then importantly, the final sentence, Judge Cannon says, I do not accept that it can be regarded as expenditure to make the plant in the facility usable. So he has looked at both the routes. Now, if we talked about 2 routes, I'd simply say that there's ultimately only one statutory question. Section 11 simply asks, is the expenditure on the provision of plant and machinery? But the findings address the correct question. The question that we're dealing with is ultimately about the proper characterisation of the expenditure. What we're looking at is an evaluative judgment about whether the expenditure is properly to be characterised as part and parcel of installing the plant, or whether instead it's expenditure of the provision of premises. And in opening, I gave the example of Bradley and London Electricity, and you can see from the summary in paragraph 83 of the first tier's decision, I emphasised in opening the point about the structure being explosion-proof. And you can also see in 83 that one of the things that was done was that the roof was designed to support earthing switches. Again, that didn't make it expenditure, didn't make the expenditure on the structure expenditure on the provision of plant and machinery. And that's for the simple reason that being carefully designed to accommodate the equipment within it doesn't make the expenditure on the provision of plant and machinery. So Lerfen doesn't advance his case by saying, well, if you look at Berkeley Curl, you can see that there are potentially 2 different routes to answering the on the provision of question. Both routes have been comprehensively, or at the very least sufficiently, addressed by Judge Cannon in his paragraph 98 sub 5. And there's no error of law in the consideration of those issues. So those were the points I wanted to make in reply on my appeal. And that takes me on to the response to the cross appeal. And just before I get going, I should just say one word about the respondent's notice. I think I meant to deal with this in the housekeeping yesterday, and and I think I forgot, so if I could just deal with it now. It's only to say this, the respondent's notice has been amended. You'll see if you look at it in the bundle, there are red underlinings marking the amendments. And I think the strict position is that because of that, we need the court's permission to rely on the amended points. It's Practice Direction 52C8.4 and 30 sub 3, because an appeal notice is defined as also including a respondent's notice. There's no objection to permission being granted, but I think formally I need to apply for the court's permission to rely on those amendments, so I'm doing so now.
Very well.
Now, in relation to the cross-appeal, I'll deal in turn with items 1 and 4 first, and then turn to item 22. And just given the time, I'll take the skeleton as read, and I'll focus on the points that Mellor and Friend developed orally, if I may. Starting point in relation to items 1 and 4 is that in my submission, URENCO is not entitled to rely on the predecessor legislation. What Mellor and Friend did, and I understand why you would seek to do it this way, was to show you the predecessor legislation de bene esse, to identify differences, and then to say, well, look, this is all terribly difficult, there's an ambiguity, we need to look back, there's no purpose to any changes, doesn't that just show I must be right, and you should construe section 23 sub 3 as including effectively expenditure on the provision of these items, despite the fact that it says on. Now, the first point I make is that that's not the right approach. The consideration of the issue in relation to item 1 and 4 needs in my submission to be addressed by construing the 2001 Act. And those issues both can and should, I say, be resolved by reference to ordinary methods of construction in relation to the 2001 legislation. And the result of that is that there is no basis for looking further back. Indeed, it is not permissible to do so. And can I just make that good? Because I need to show the court a couple of authorities on that, because the position is slightly more involved than the references to Derry may suggest, to which you were taken this morning. Can I start, please, with what Mr. Justice Sales said in Eclipse, because we saw this was guidance, some of which was expressly quoted by Lord Carnworth in Derry and approved. But what Mr. Justice Sales was doing was actually applying guidance that one gets from Farrell and Alexander. So if I may, if I can show you Eclipse very quickly, then Farrell, and then I need to show you what was said in a case that I helped to lose for the revenue called NCL Investments, where there's actually some commentary in relation to Derry. So I'll do that, if I may, as swiftly as I can. So Eclipse first. Authorities tab 2, Authorities volume 2, tab 35. And the key passages are 96 to 98, which are at bundle page 645. Just to summarise what this issue was actually about, I mean, this was the well-known piece of film finance litigation. And if you go back to paragraph 86, there was an issue introduced by the taxpayers in that it was said that the first tier had gone wrong in thinking that there might be a concept of a non-trade business. In paragraph 86, essentially it was being said, well, there was no such concept in the old law. The Income Tax Trading and Other Income Act was looking to rewrite the old law. It wasn't looking to make changes, and so this new category didn't exist, essentially. The guidance that Mr. Justice Sales gives starts at paragraph 96. 96 is his observation that the explanatory notes indicated that this part of ITOIA should be approached and interpreted in the same way as a Consolidation Act. He then summarises what was said in Farrell and Alexander. And because of the way my friend put his case, I will also show you Farrell and Alexander. But the first point he makes is that the principal inference, this is by the letter J, is that the consolidated statute should be construed as a single integrated body of law without any need for reference back to the same provisions as they appeared in earlier legislative versions. And that followed because of one of the objectives of the rewrite project of gathering disparate provisions into a single, easily acceptable code. And he makes the sensible point that that objective would be undermined if you needed constantly to refer back. And so he says the main task is to construe itoia, so that's the rewritten law, without reference back to section 18 ICTA and Schedule D, that was the pre-rewrite law. What he says next is important. He says, however, where after undertaking such an exercise, a provision which falls to be applied is found to be ambiguous, a subordinate presumption comes into play, and that's that it's presumed there was no intention to change the meaning of the provision, which has been repeated in the same language in the consolidated code. In such circumstances, it may be relevant to try to determine the meaning of the relevant provision by looking to see what it meant when it was previously enacted. And what's important about this is that the gateway is identifying an ambiguity. And unless and until there's ambiguity, it is not permissible to go back to the old law. And one can see that in 98, because Mr. Justice Sales, he decides the case on the basis of his view that there is no ambiguity in section 609. And that reflected what the House of Lords had decided in Farrell and Alexander. And I just need to show you that, particularly in the light of what's said about Derry in NCL Investments. I'll do this quite quickly. It's volume 1 of the authorities, and it's tab 15. And there are speeches going in different directions. There's quite a lot of discussion. I'm simply going to focus on the key parts of the majority, given the time. But this was looking at the Rent Act, and in particular looking at how to interpret the words any person within the Rent Act. And it was the Rent Act 1968, which was a consolidation act. And one of the arguments involved going back to predecessor legislation and tracking the wording through. I can pick it up in the speech of Lord Wilberforce. It's report page 72, bundle page 154. And at letter E and following, he refers to the House of Lords' previous decision in Monsell and Owlands, and he says he's going to try and clarify what was said there. And he refers to two of their lordships in that case having thought that the provision was clear. That was Lord Diplock and Lord Simon. And there were those who thought it ambiguous, and that was the majority in that case. And he explains the basis why he thought there was ambiguity. So there was no primary or certain meaning, and the section admits, almost invites opposing constructions. That was why he found it necessary to look at the antecedents, he says. And then he explains that Lord Diplock and Lord Simon, they thought it was clear, and so it wasn't legitimate to go back into the legislative history. Lord Wilberforce says, if I may say so, on that hypothesis, I would agree with them. So if he'd taken the same view about clarity, then the minority in that case would have been right, because he then says, I endorse the principle that it's quite wrong, that in every case where a consolidation act is under consideration, one should automatically look back through the various provisions, etc. And he notes the length of time that then is occupied in argument. And then over the page 73, just above the letter B, he makes essentially the pragmatic point that unless the process of consolidation is to become nothing but a work of mechanical convenience, that's the tendency to look back should be firmly resisted. Self-contained statutes should be interpreted, if reasonably possible, without recourse to antecedents. Recourse should only be had where there is a real and substantial difficulty or ambiguity which classical methods of construction cannot resolve. And he notes that that's particularly true of acts such as the Rent Act, have to be applied by county courts, have to be understood or at least explained to great numbers of citizens. Well, one might draw some analogy with a taxing statute addressed to the public at large, and where self-assessment has to happen. So that was Lord Wilberforce. I'll just show you very briefly Lloyd Simon and then Lord Edmund Davis. Lord Simon gives some guidance of his own. It's quite a lengthy passage. I don't read all of it. It starts on page 82 at the letter B. But I can pick it up on page 84 at the letter E, where he says it's only on the failure of the primary aids to construction. I'll take it back to one sentence. That the primary approaches to statutory interpretation, they're as appropriate for construction of the Consolidation Act as for any other type of statute. Well, that's clear and obvious. And he says it's only on failure of the primary aids that the fact that the statute is a Consolidation Act permits any special approach. And that's when the secondary presumption of no change in law being intended comes in. And he goes on to develop that at the letter F, talking about the court placing itself in the position of the draftsman. And he says, but occasionally something will go wrong. There might be injustice, absurdity, anomaly, or contradiction. Or it might stultify or run counter to the statutory objective, or there may be no primary meaning. And he identifies what he means by ambiguity in that context, and then he refers to there being secondary canons of construction available to resolve ambiguity. But he goes on to say this is just like, this is nothing of the foregoing, this is just above H. Does the construction of the Consolidation Act differ from that of any other statute? Its only peculiarity is that if the primary approach to construction discloses an ambiguity in the Consolidation Act, that may sometimes, though rarely, be resolved by examination of the superseded legislation. But his view in that case was that there was no ambiguity. And then Lord Edmund Davis is to similar effect in relation to ambiguity. And I only need to show you page 94 in the report, bundle page 176, at the letter D. It's legitimate to refer to an earlier statute in pari materia, even if it has expired or been repealed, but only where there is ambiguity. And then he refers to what Lord Simon had said in Monsell about the presumption that Parliament does not intend by consolidation to alter the pre-existing law, but that is no scope for operation where the actual words of the Consolidation Act are not, as a matter of legal language, capable of bearing more than one meaning. To tails wagging dogs, and I'd respectfully submit that that's exactly the exercise that my learned friend's inviting here. And so what Lord Edmund Davis does is ask, what is the section ambiguous in the sense that it's a matter of uncertainty, whether the particular arrangement falls within the wording. And then over page 95, letter D, his conclusion, and this is applying ordinary methods, is that no room for doubt exists that the section does apply. So that makes good in my submission the point that there needs to be an ambiguity in the sense that the courts have identified. So not merely that there can be argument about what the words mean. It's a more narrow sense of ambiguity than that. We looked at the passages from Derry. There's the reference to Mr. Justice Sales. There's then Lady Arden's reference to pre-rewrite case law. And just so the court has the up-to-date picture, I should quickly show you what was said in NCL Investments about this, because what that does is really reassert or suggest that one mustn't forget, at least Farron and Alexander. NCL is Authorities File 3, tab 46. I don't think I need trouble the court with the detail of the issues that were in dispute in that phase. There was a point that the revenue relied upon of referring to a very old case called Lowry, which had been decided on the meaning of pre-rewritten provisions of ICTA, where money laid out or expended was the statutory wording, and the revenue said that Lowry suggested that there had to be an actual spending of money. In the rewritten legislation, the statutory concept was expenditure incurred, and one of the points made was to say, well, expenditure incurred was not intended to change the meaning of the old law, and so the approach in Lowry should continue to apply. The revenue lost essentially because the statutory wording was different, but just so the court has the picture of this, the Supreme Court dealt expressly with Derry in paragraphs 44 and following of their judgment. It's bundle page 988. I think it's 1843 of the report. And they note at 44 the reliance on Lowry. They then refer to the guidance given in Derry, that's paragraph 45. And then at 46, it's the point, which doesn't actually arise in this case, that in Derry, Lady Arden said, well, there may be different principles when it comes to prior case law. Prior provisions might be one thing, but prior case law might be another thing. At 47, they say those comments weren't necessary for the determination of the appeal, and there hadn't been any argument about the effect of Farrar and Alexander. And they say they don't need to decide whether what was said in Derry is consistent with what was said in Farrar and Alexander, or how that would apply to a tax law rewrite project statute. But they sound a note of caution at the end of paragraph 47, and in particular in relation to earlier case law. So that's the latest guidance from the Supreme Court on this. It doesn't leave it perhaps in the most definitive state, but what I do say is it's the Farrar and Alexander principle that one still is bound by.
Just for completeness, Mr. Bremner, I should mention, in case you're not aware of this, about 3 weeks ago, this court handed down a judgment in a case called Quentin Squinner. Settlement, in which it happens, I gave the judgment, and it did involve an issue of this type as to whether one should look back at earlier versions of legislation. And I think we took the view that, certainly in that particular case, there was no sufficient justification for doing so, and that we should apply the principles set out by Derry and also by Mr. Justice Sales in Eclipse.
I'm very grateful for that.
So I don't think that's going to throw any further illumination on this.
It doesn't.
But I thought I should mention it just in case anyone wishes to.
I'm grateful. I'm grateful for that. I was aware of the case, but not that it had dealt with that particular point. So, if I may, I'll educate myself about what was said on that on that issue. So the submission that I made, because one has to be careful, particularly when one looks just at face value at what is said in Derry, when it says, for example, it would not generally be appropriate. One said, well, what does that mean? It may actually be quite easy, one might think, to find a justification. What I'm saying is actually when you look at Farrar and Alexander in particular, and also at what Mr. Justice Sales was saying, applying that in the tax context, this is actually quite a limited ability to look back.
Look, it may be quite limited, but I mean, courts never like being told they can never do something, and this it really is absolutely.
I understand
100% clear, and this, all I'm putting to is this could be a case where there is sufficient doubt raised just by looking at the Consolidation Act itself as to whether Parliament was intending to make a distinction between expenditure on and on the provision of, in the context of column C, given the absence of any explanation put forward by the revenue as to what the purpose of such a distinction might be in this context.
Well, I wouldn't accept that, because it may be that the easiest thing to do is just actually to do this with the 2001 Act open in front of us, because one has to, if I am right, that the starting point is that one has to approach this by reference to normal canons of construction. One has to put to one side any baggage that one might otherwise be carrying, either from the 1990 Act as amended in 1994, or indeed as a result of prior practice. What one has to do is to look at, in this case it's in particular section 23, and one has to say, well, does what Parliament, or is it the case that what Parliament has done makes sense, applying normal principles of interpretation? Are we able to resolve the scope of these controversial items in List C, in particular item 1 and item 4? And what one will see in doing that exercise, as the upper tribunal rightly noted, is that Parliament has used two different formulations. It's talked about expenditure on any item, and it's also identified expenditure on the provision of particular items, and you see that within the list itself. And you also see that within 23 sub 3 in a similar, in a not identical, but a similar way. So there is different legislative language that's being used, and applying normal methods of construction, one would take as one starting point that the choice of those different formulations was an intentional one, not an accidental one. And as the upper tribunal, in my submission, rightly said, one would simply say we need to respect the fact that there are these two different formulations used. It's not for us to equate one with the other without a proper basis for doing so. And the difficulty my learned friend has is that he only gets into his merits points, if I can call them those, or prejudice points, if he's allowed to look back at the old law. Because if you simply look at this provision on its own, the scheme that's been enacted actually is perfectly sensible, and nothing that's been said would justify equating on the one hand and on the provision of on the other.
May it not be said that the language of 23 sub 3 itself does tend to suggest expenditure on any item and expenditure on the provision of plant or machinery indicate that these are perhaps different ways of expressing what's basically a single portmanteau concept. I mean, the way the legislation is framed, and going back to the underlying test in section 11 and so forth, it's ever since Yarmouth and France, I mean, the whole question has been addressed in terms of provision of plant or machinery.
So the statutory question is there expenditure on the provision of plant and machinery? That's absolutely right.
Yes.
And indeed, I positively rely on that when it comes to my
Well, I know you did.
to my ground 3.
I was going to almost put it to you then. At that point, you seem to be accepting that this was really a single concept.
It's one concept, but what has been done here is that language is being used that identifies two different items with different scopes, and one can see.
Well, that begs the question with respect. There are differences in language, but they could be two ways of saying the same thing.
Well, they could be, but what one has to do is interrogate what it is that the draftsman has actually said. What's the draftsman done by using the two different formulations? And the point that's particularly important here is if one looks back at the case law, and Parliament would be taken to be aware of that case law when enacting this provision, you can see, for example, from Berkeley Kernel, that expenditure on the item relates more directly to the item itself, and on the provision of is a more expansive notion. You can see that, particularly from what Lord Reed has said. And Your Lordship puts to me, well, aren't you begging the question? What one has to explain is why it is that in this list, certain items are simply identified on their own, and then in 26 and following, one has a different notion. Towers to support floodlights. It's not just towers to support floodlights, it's the provision of towers to support floodlights. And I do say that the prior case law does help to elucidate what would have been intended in that context. Now, I equally understand the court.
Can we just pick that point up? I mean, I can understand the submission that says if you just took 23.3 on its own, you can see that it distinguishes between expenditure on any item described in List C and expenditure on the provision of plant or machinery. So I can understand why your submission is, if you just look at 23.3, that on its face is making the very distinction that you are relying on.
Yeah.
As a matter of language. However, one can't read 23.3 on its own because it cross-refers to List C. And then you find when you go to List C that you've got things like cookers in 5, you've got refrigeration, cooling equipment in 9, fire alarm systems in 10, burglar alarm systems 11, and so on and so on. And 22 is a special case for obvious reasons, but then you come to 23, and suddenly the language has changed. It's not dry docks, it's the provision of dry docks. And so, is it not, just looking at List C, odd, to put it no higher, that suddenly we have a change in the language halfway through the list for no apparent reason?
I wouldn't accept it's odd. No, I mean, the genesis of this list, I suppose, in its own way, might be characterised as slightly odd. I mean, there isn't any particular unity or rationale to all the various different categories. I would simply say that what one sees here is the drawing of a line, and the line's been drawn in one place in 23 and following, and in another place in 1 to 21 and 22, as just as Arnold rightly says, is perhaps a special case because we're talking about
I might see that's a possible interpretation, but you have to go further than that, don't you? I mean, if another possible interpretation, as my Lord has been putting to you, is that this is a very odd-looking change of register halfway through without any explicable reason for it. If one looks at the explanatory notes, one finds no hint at all of any suggested justification or explanation of why one finds this change halfway through the list.
Well,
and isn't that enough to constitute an ambiguity which makes it relevant for the puzzled reader, whether self-assessing or not, to say, well, can we get some help from what the previous legislation said?
One has to be very careful about the notion of change. I'm assuming your Lordship is putting to me the notion of change, that there's a change as between 1 to 21 and then 23 onwards, because we can't get to change in a before and after sense
yes,
without looking at the...
There is a change in the way in which the items are phrased. And if you underline the word provision every time it appears, from 23 down to the end, you have a dozen items beginning the provision of, whereas 1 to 20, 1 to 20, 1 to 21 are all absolutely naturally introduced by the word on, or at least can be.
All I would say is that doesn't give rise to any ambiguity of the sort that's identified in Farrell and Alexander. That entitles one to look back.
Well, Wilberforce did say any difficulty, substantial difficulty or ambiguity. He did put it slightly wider than ambiguity, which in itself is sometimes quite a difficult word to construe.
It's not a substantial difficulty. It might simply lead one to say, well, I find myself wondering why Parliament drew the line in that way, but ultimately one would have to respect the choice of language that Parliament has adopted here. I'm simply saying it doesn't engage any of the principles that allow one to look back further. And if one takes, for example, Melford tried to make something both in his skeleton and already, it's saying, well, it gives rise to very odd results, so some of the cases just wouldn't work. And I don't accept the examples that he gave. I mean, for example, the Cook and Beach Station's caravan example, you say, well, that would be reversed. But we saw in the discussion with Lord Justice Arnold, actually, it may well be that 22 would have applied anyway. Equally, if you're looking at expenditure on a swimming pool, digging out the swimming pool in that particular context, you probably don't need the language of on the provision of to get home on that anyway, because it's all part and parcel of creating the swimming pool. So there's nothing in my submission on item 1 and 4 that justifies the look-back process that's being contemplated. I also say, and I recognise that this is a point that this court may be reluctant to get involved in, but I make it nonetheless, that actually whether we're looking at on or on the provision of, neither concept would actually apply here. This is the point in the skeleton and in the respondent's notice. And the reason for that is that actually if you're looking at the expenditure that Mellor Friends are relying on when it comes to item 1 and item 4, actually, this is all expenditure that is more aptly characterised as being to do with the provision of a building rather than the provision of machinery or the provision of equipment. Because one also has to bear in mind with this, what Mellor Friends looking
Sorry, just before you go on, that particular point, I understand why you make it, but isn't that something that would have to be remitted?
Well, and that's why I say I can see that this court may be reluctant to actually get involved in ruling.
Because that's not something that...
There were no findings on,
exactly.
on that particular matter. What one can see, and I'll just make this point swiftly, is that we're looking at an exception to the exclusion. It would be very surprising if the exception were simply repeating the common law test for plant. I mean, that's not really congruent with having new rules intended to draw a line in the sand. And one would have thought that actually what's necessary is a further exercise of asking, okay, well, looking at the list, expenditure on the provision of machinery, I mean, that makes it particularly stark, because that's anything that passes the common law test. Really, one ought to be looking at, is this better characterised, is this item better characterised as part of the building or actually as part of the provision of the equipment? But I can see that for this court, sitting in an appeal on the law only, you may not want to go there. I just put a marker down about the items themselves, because what certainly is wrong in my submission, you can see Mellor Friend trying to do this in his skeleton, is to try to expand the scope of the items for which he relies upon item 1 and item 4. And this is a point I flagged in our skeleton.
But again, if the matter were to be remitted, that would be an issue of the FTT.
Well, it might be. I'd prefer that that this court simply confined the remitter to the items where the point's already been taken. I've got no desire to see the scope of this litigation getting expanded, not least because of the rather...
Oh, sorry, you mean the assets? You're
Yes,
talking about the assets to which items 1 and 4 might...
Because the procedural history set out by the FTT, you'll recall, Lord, I objected strenuously to the point coming in at all. And on balance, I think was the phrase that Judge Cannon used. I might have he permitted the point to be raised, and that was only in relation to 5 items that are set out in FTT 141. It's 2 plinths, some access hatches,
so
etc.
URENCO have permission to raise this argument in relation to those 5 assets.
Yeah, what Mellor Friend is now saying is, well, now that we now know that these principles might be a bit different, I'd quite like to look at other things and bring those in. I'm saying, no, you can't have a second bite of the cherry to do that.
Yeah, that's a different point.
You were already late once, and you shouldn't be looking to take advantage of that. And this next point may take care of itself, but this is the point I make in Skelly at paragraph 24. The item 1 and 4 argument, and this is common, it only works for items that have been accepted to be plant. Now, if the court's with me that the first tier was right, right in its consideration of the plant premises issue, then actually the 5 items that are potentially relevant to item 1 and 4, they come down to 3. And again, I've got no desire to see those being expanded. The last point that I would just gently make, listening to my learned friend this morning, but it's also relevant to some of the observations that Launcelot Henderson was putting to me, is just to note section 23 sub 4, because that does provide a bit of a clue, and I would say some support for the point I'm making about link with building, because you can see that for items 1 to 16, so that includes item 1 and item 4, which we're arguing about, you exclude assets whose principal purpose is to insulate or enclose the interior of a building, or to provide an interior wall, floor, or ceiling, which in each case is intended to remain permanently in place. And if you just think, I mean, for example, one of the items is the access hatch in the kiln facility. If you look at the block diagram at page 196, it's item H. It's part of the roof. So it's quite hard to see how Mellor actually, in the end, gets home on any of this. Similarly with the plinths. Plinth's just part of the floor. But as I say, that it may be that that's a discussion we have to have on a remitter, because the first tier in the upper tribunal did not get into making detailed findings on those points, because they looked at it as a matter of principle. But I do say that is at the very least a clue that the sorts of concerns that Lloyd was putting to me, actually my interpretation is a sound one, as indeed both tribunals below thought.
Well, I quite see how you work your way to that conclusion on the basis of the principles of construction and so forth. And it may be, applying the law as it is, that's the way we have to decide the point, ultimately. But it would be easier to do so if we did have some clue as to what the revenue was actually thinking it was up to when it introduced these list C, phrased in this particular way in 2001, in the context of an act which was not designed to make major changes in the law, but only minor changes at the most. And when it did so, one would expect, of course not always, the case that would be signalled in the explanatory notes. But we have no assistance of that nature at all. And Mr. Peacock is surely right to say, though, this is actually potentially a very important point, huge amounts internally. If you look at Berkeley Curl, for example, the expenditure on excavation and the concreting was by far the bulk of the expenditure which was in issue in that case.
I wouldn't accept that whether it's on or on the provision of is a huge point. What it would then require is actually a factual inquiry into the scope of those words in any particular case. I mean, the sort of councils of doom that,
well, all right,
capital allowances specialists up and down the land are getting very anxious about this. I think are overstate. Because what one would have to do is to inquire in any given case about whether there is a close enough relationship between the expenditure and the particular machinery or equipment for it to count. And one would have to look, for example, at the point about, say, delivery fees and the like, and one would have to ask, as a matter of construction, does that count or not?
Well, that may be so, but I mean, that in a sense reinforces the point, doesn't it? It's surprising to find in this kind of a context that sharp distinction being drawn between expenditure on an asset and on its provision, when really, for as long as this has been the subject of any detailed legislative consideration, we have the portmanteau phrase on the provision of plant or machinery.
Well, it's only in the context of the exception to the exclusion, and experience does tell that quite sharp line drawing happens in the statutory provisions without specific explanation in explanatory notes or otherwise, and one is simply left to say, well, this is where the rule has set the position, and I have to do the best I can with it. And I do say that really is the position that we're in relation to items 1 and item 4. It's absolutely right that I'm not able to help with some policy paper or something in the explanatory notes that says this is the rationale for the difference in language. I absolutely accept that. But what I simply say is that one has to do the normal exercise of construing the provision, and one is able to do that, and that's what one should be doing. And then if I'm wrong about that, we get on to the points that I've made about, well, actually, how does it play in practice in relation to the interpretation, because there's a lot more to it than simply on the provision of comes in and therefore Mellor friend wins. That's not the position at all. I'm conscious of the time, milady. I was going to pass on to List C item 22, unless I could help further on item 1 and item 4. On List C item 22, the key finding was that even if there was an alteration of land, URENCO had purposes which went beyond the installation of plant and machinery. That was paragraph 151 in the first tier. And the purposes which were identified were protecting operatives, the public and the environment, and to provide premises which house the plant and machinery. And I'd say simply that the FTT was perfectly entitled to reach that conclusion, and there's no error of law in the conclusion. It's very striking that to get anywhere on this ground of appeal, Mellor friend has to rely on a very expansive notion of installation. I read his skeleton a number of times and was quite puzzled as to what the notion of installation that was being relied on actually was. It's not really explained. We got a little bit closer this morning, where I think at one point it was suggested that installation encompasses an aim of creating a location for the plant and machinery to be used safely. That's the notion that's being put forward. And I say, both as a matter of generality, but also specifically in this statutory context, and that's the real question, that is far too broad an approach to the notion of installation. First of all, it's very clear in my submission, this is not intended to be a broad exception. You can see that in particular from the use of the word only in item 22. And certainly the first tier was perfectly entitled to say that protecting operatives, the public and the environment, and providing premises, they weren't installation purposes. Because even if you look at the purposes that Mellor friend relied on, so the provision of shielding, containment, seismic qualification, those purposes are all to do with not just installation, not just putting in place and making it work, they're to do with the ongoing operation of any equipment within the facilities. But critically, they're also to do with the carrying on of the overall processes in the TMF. So if you look, for example, at the cylinder handling facility, it's not just that the structure, and don't forget, I'll come on to this point in a little more detail, Mellor friend's case has slightly evolved this morning because he's put a lot more emphasis on actual equipment within the various structures. But the way he put his case below, and the way he was putting the case in the skeleton, is that the plant is actually the structures themselves. It's important not to lose sight of that point. But the reason that you need, for example, the concrete walls in the CHF is not just in order to make equipment within the CHF work. It's because the tails that have arrived at the CHF, they give off radiation themselves. It's all to do actually with the ongoing process, not simply the operation of the equipment within the particular facility. Equally, in the uranium oxide store, the tens and tens and hundreds eventually of DV70 canisters, they're going to be sitting there for 100 years plus, up to 100 years plus, emitting radiation. The reason you need the concrete structure is actually to attenuate and contain that radiation. This is far more than simply installing items of kit within each of the facilities, which is the way that the point was put this morning. And actually, the way in which Mellor friend's submissions recorded by Judge Cannon in the first year, it does rather give the game away, because if you look at paragraph 151, the submission was that each of the disputed assets, this is 5 lines down, was designed and constructed solely with a view. I'm so sorry.
What's the page reference?
I'm so sorry. It's bundle page 250.
Thank you.
So sorry. It's paragraph 151 in the FTT. And 4 lines down, the submission was that each of the disputed assets was designed and constructed solely with a view to enabling the installation and safe operation, and I underline and safe operation of the TMF. It's not just to do with making plant or making equipment within the facility work. It's all to do with the processes as a whole, which goes above and beyond that. So even on the way Mellor put his own case, there were at least 2 purposes. But the wider point I make is that that conception of installation is just too broad. And one can see that if one tests what it is he's actually looking to apply C22 to. Because it said, well, this installation purpose, it encompasses the creation of entirely new structures. So for the first time, before these various facilities were constructed, there wasn't a CHF, a kiln facility, a vaporisation facility, a uranium oxide store, etc. These things didn't exist. They were brought into existence. That's the thing that has generated the expenditure in respect of which the plant and machinery allowances are claimed. So if there was an alteration of land, and I've got some submissions to make about that, let's just assume against me that there was. The purpose of the alteration, at least in part, was to create these large warehouse-type buildings. You can't shut your eyes to that. You can't say, oh, well, this is all only for the purpose of installing machinery within the buildings. That's just not a realistic way of looking at the matter. And the FTT was exactly right to reach that conclusion. The general confusion that Mellor seems to have made is really in equating installation with provision. He seems to say, well, anything that involves getting kit in a state to be working, that counts as installation. But that is much too broad a notion. Mellor hasn't addressed the point that on his case, creating new premises, it would count as installing plant. That clearly would undermine the statutory scheme. His approach is not consistent with what was said by the upper tribunal in SSE. He tried to get round that. I mean, you'll recall in the upper tribunal, it said, well, this is about bringing one thing into another in installation. We looked at those paragraphs. I can show you them again if you want to see them, but I suspect you don't need to see them. Mellor tried to say, well, that doesn't meet the case he was putting because he's relying on the kit within the buildings. But that ignores the case that he's actually running, which was that each of the structures was an item of plant. And it also ignores the reality, because even if you put that to one side and you say, well, let's just focus on particular items of plant within each of these buildings, necessarily part of the purpose is to create some buildings. And it's just not a realistic view of the facts. It's not a sensible interpretation of the notion of installation in this context to arrive at such a broad view in my submission. Can I deal next with alteration of land? And then the last point I want to make is that actually as a matter of approach, and I understand why Mellor has done this, I suspect I would do the same if I were in his shoes, but it's wrong to divide up item 22 in 2 compartmentalised ways. It's one overall phrase, and actually the various limbs of the item do shed light on what's going on. So I want to make a final point about that. But before I get there, I just want to deal with alteration of land. This was the point that's left open, both by the first tier and by the upper tribunal. And quite a lot of time was spent below on the significance of the Interpretation Act definition of land. And you recall Mellor taking you through the current law and also the old law and making the point about different definitions in different places and that sort of thing. Actually, when one gets to it, regardless of whether one takes the Interpretation Act definition, I do say that in this case we wouldn't have an alteration of land in any event. The starting point in my submission for this, and this is the point really that we trail at paragraph 45 in the response skeleton, is that Parliament sees the alteration of land as something distinct from the provision of a building. We know that provision of a building is dealt with in section 21 expressly. Provision includes its construction. Works involving the alteration of land, they're dealt with separately in section 22, particularly section 22(1)(b). And you'll recall from the opening that there are those two specific instances where particular types of building are identified as benefiting from the exception. That was the buildings for testing aircraft engines in item 20 and the movable buildings in item 21. And I do say that in context, constructing a building on land, it doesn't answer to the description of altering land. And the reason for that is that what you've got is that something new has been built upon the land. And it's very difficult to square that with the fact that you have Parliament identifying provision of a building and indeed its construction as one thing, sticking with that into items 20 and 21 in list C, and then doing something different, alteration of land in item 22. And
can I just see if I understood that submission? Because if I've understood you correctly, that is a submission not about the meaning of the word land, but about the meaning of the word alteration.
Yes, that's right.
Yeah.
That is right. And that's why I say it doesn't actually, it's not affected by whether the Interpretation Act applies as it stands or whether there's some modification because of context to what the Interpretation Act says. I mean, all the Interpretation Act tells you is that land includes building, but in our particular context, there weren't any buildings in the first place. So it's actually rather difficult to see that the Interpretation Act really helps the analysis.
And I guess put another point to you. I mean, we've been told, and it's obviously, I think just from reading the list, that a lot of these examples, probably the great majority of them, are really intended to encapsulate the point in some decided case, which was intended to be preserved for the future. And the types of cases spring to mind when we're looking at item 22 are ones like the swimming pool case and the dry dock case.
Absolutely.
Which are both cases where you start with effectively a brownfield, a pretty clear piece of land, which has to be adapted for what turns out to be the reception of a substantial piece of plant.
Yeah.
And in the case of Berkeley Curl, it not only had to be excavated, it had to be lined with concrete before the actual dry dock itself could be constructed. So really my question is, how far is it right to have that kind of, those specific instances in mind as a kind of guide to what it is that this rather more general looking language is really driving at?
Well, it would in my submission help by way of context, and it would also help in this sense that one would be very surprised if the exception in item 22 were actually to swallow up the rule.
Well,
in section
yes.
in section 21, and that's the trouble with Mellor and Friends' case here, because don't forget he was saying that the entire building is plant. So what he's doing in my respectful submission really is just looking at the matter too literally.
The kind of argument proves too much.
Yes.
In the sense that we're looking here at carves out from exceptions, and one's instinctively disposed to adopt a fairly narrow approach to language in that kind of a context, especially when you look at the very minutely granular nature of a lot of the items we're talking about here. Sinks, baths, showers, they're all very...
It's very specific.
Specific, and
quite
often
so.
very small scale as well.
Quite so. And one's encouraged to that narrow view by that use of the word only.
Yes.
In item 22.
So, I mean, the words alteration of land in a different context could be almost incredibly wide. can encompass almost any operation on land which has some effect on it. But
And I suppose that's why, ultimately, having reflected on it, this is now the third time of arguing this case, I'm thinking that actually, where one risks going wrong is by sort of putting goggles on and looking at each element of item 22, which is the risk that the Line of Friends approach carries of saying, well, alteration, tick, land, tick, now let's look at purposes. Actually, we're looking at a particular kind of alteration, and the entirety of the item, each element of the item sheds light on the scope of what's intended. And seen in that way, and this is the point I make in the skeleton at paragraph 49, that helps one to understand why in this particular context one should not be arriving at a construction where the alteration in question is said to include either creating plant itself, that's not actually covered by item 22, that's my friend's maxi case, because otherwise one would rather have expected an item to have said so, but also it's not apt to include creating the place in which plant happens to be situated. And if we go back to the normal notion of installation, again, we saw that in SSE Upper Tribunal, and then they cited the engineering industry case, it's obviously in a different statutory context. But installation has a connotation of putting in place something that's already been made so that it can be used. And certainly in engineering industries, maybe it's worth actually showing you that very briefly in the original. That's Authorities 1, tab 12. Because this was the case that the Upper Tribunal was in part relying upon in SSE. It's a different statutory context, but they were looking at essentially assembling a boiler, and the question was whether that came within the notion of installation. And I can just show you a couple of short passages in the speech of Lord Wilberforce, page 887 of the report, bundle page 108. He says it's a metaphorical word, that's just by the letter C. It's not a word of any great precision. And so, of course, the context is very important here. But as to what it conveys, he referred to a Canadian case, City of Winnipeg. And that makes my point, that associate words show through and give their colour and meaning to it. And that's why I say that those other words alter. The fact that installation, we're looking at that in the context of an alteration of land, and equally the alteration of land is in a context where the sole purpose is the installation of plant and machinery. That's a helpful way of thinking about this. But the point about installation is by the letter E, it conveys putting in place something already made so it can be used. And he notes the problem, and this is a problem that arises in this case. I say that actually it's a misdescription at letter E to say that the boiler is installed in the framework of the building. And what was happening there was that the framework was there to hold and cover the boiler. He also goes on to make observations, and this is by the letter H, that if one gave too literal an interpretation to the exception, little would be left of the specific item. There's an analogy there with the point I'm making about section 21. And actually the same point arises in the judgment of Lord Justice Phillimore, report page 889. At the letter B, he notes that the object of the schedule would have been defeated if you took an unduly broad view. So Well, I take it in stages. I say if you look sort of element by element of item 22, there isn't an alteration of land in any relevant sense. I say in any event that the first tier was fully justified in holding that the purposes went beyond mere installation. That I say is obviously right. Didn't involve any error of law, and actually that's the end of the matter. But also that's reinforced when one, as I say, one should, just stands back and says, well, actually, we have to be a bit careful about looking at this in too compartmentalised a basis. One needs to look at this in the round, and those observations in engineering industry, I do say, are just quite a helpful reminder in that context. The fundamental point I make on item 22 is that nothing that's been said gets even close to showing that there was an error of law in FTT 151. And on that basis, one doesn't actually need to get any further.
It's interesting to find Lord Wilberforce sitting in the Court of Appeal. Must be about the only case that he ever did, I think.
Yes, I don't know.
Anyway,
how that is.
By the by, he was promoted straight from the High Court to the House of Lords.
I was just going to make one last point, which is on if one does get to the stage of there needing to be a remitter, and the court has my submission, we don't get there. This can be determined without remitter. I think the case that Lord Launcelot Henderson was mentioning was actually a case I think it was Newey. May have been the case that Your Lordship had in mind, where there was some debate.
Yeah.
VAT case where there was some debate about whether the remitter there was held there should be a remitter from this court, and there was debate as to whether it should go to the upper tribunal or to the first tier. Held it should go to the first tier, and absolutely, if this court gets to the stage of saying that there should be a remitter, then clearly it should go to Judge Cannon for actually the reasons that Leonard Friend gave, because this court is in much the same position as the upper tribunal in terms of the ability to remake, so it should go back, if it has to go back to Judge Cannon. But my submission is that the appeal can be allowed, the cross appeal dismissed, and that brings matters to an end without any need for a remitter. My lady, unless I can assist further, those are my submissions.
No, thank you very much.
That leaves me just to reply on the list C issues, which is my appeal. Taking them in order, C1, C4, you heard from my learned friend say, in effect, at least in this case, one can't look back to the earlier legislation. I addressed that in opening. We saw the passages in Derry. There's nothing, I think, we get extra out of Eclipse, but there is recognition there, as one might expect, that there's one instance in which it may be appropriate to look back is through the gateway of ambiguity. Now, either on here does mean read in context, on or on the provision of, or not surprisingly, you may think, if that's not so certain, then I would say respectfully there is the relevant sort of ambiguity here that would allow you to look back. As my Lord Justice Henderson noted, even in Farrell, the way Lord Wilberforce puts it, is a real and substantial difficulty or an ambiguity. I forget which member of the judiciary wrote a paper about the 7 different sorts of ambiguity, but there is quite a famous paper recognising that there can be many different sorts of ambiguity. We don't need to get bogged down in that, but it is helpfully put by Lord Wilberforce as a real and substantial difficulty or an ambiguity. NCL is a different point. The point that the Supreme Court reserve in NCL is the separate debate about whether, and if so when, it might be appropriate to look back at earlier case law. They weren't saying anything about Farrell and Alexander and Eclipse as regards earlier iterations of legislation. And my Lord reminded us both of the Quentin Skinner case, which my junior Mr. Ripley was in for the revenue, and he rightly reminds me that in effect in that case what this court said was it wasn't appropriate in that case to look back. Having quickly looked at the judgment, we find no expression of principle to the effect that one can never look back.
No, and that's why I didn't actually think it would advance the debate here, but I thought I should mention it just in case anyone took a different view.
I'm obliged. My friend then said, well, section 23.3 makes sense on its own terms without the need to look back. And we say, well, if that is the exercise one engages in, that's not the position. One knows from section 11, subsection 4, that the scope is on the provision of plant or machinery. If necessary, I would submit that clearly here covers both on and on the provision of. And there's nothing in section 23.3 itself that points conclusively to the opposite conclusion. And it would be rather odd if you then had a list of partial exclusions by reference to one notion of on expenditure, and then part of that list of exclusions would be on the provision of, in circumstances where my learned friend, when pushed a little hard, accepts there is no rational explanation that he can offer for that change. So in those circumstances, we stand by the submission I made in opening. The only other point that he made under that heading was to say, well, perhaps it is clear that Parliament wanted to draw a line, by inference in the sand again, but it really just is an assertion that Parliament was drawing a line in the sand between some items in C that would be on and some items that would be on the provision of. To say it's deliberate is really just to restate that that's what it appears to say on the face of the statute without actually explaining why that might be so. My friend also said, well, my point about Cook being reversed would be wrong because it could be saved by C22. Of course, that's rather inconsistent with the stance its clients are taking in the SSE litigation, because in Cook, you would be creating the asset in situ. You're creating the swimming pool. And yet the stance the commissioners take in the SSE litigation is to say, well, that doesn't fall within the ambit of C22. C22 is about putting pre-manufactured items in a place, not building an item of plant in situ. So C22 is not a saving answer here to the result in Cook, at least on his client's view of the world. And he then says, well, perhaps here it would be better seen as on the provision of a building, but he rightly recognises that there's no findings of fact to that effect because the First-tier Tribunal was not required to address that question. And he then makes the point about the procedural fight, if any, between us about what assets this might apply to. In fact, we identified 6 separate assets before the first tier, which we said were within C1 and C4 if the argument got that far. Some of those were accepted to be on the provision of plant by the first tier, and some of them were not. And we relied on all of those items falling within C1 and C4 if need be in the upper tribunal. There were 2 additional items in the first tier where the first tier found assets that we had not pointed to C1 and C4 as being on the provision of plant. And that was the kiln facility and the condenser facility. So what we said in the upper tribunal is, well, we must be entitled to rely on C1 and C4 as regards those items as well, because that necessarily follows from the first tier's decision. Now, that was left unresolved, but that, if there is to be a remitter, would be an exercise that should here be done by the first tier, and without much greater submission, both in terms of time and detail, this court's just not in a position to rule on that exercise. Now, we can descend into it, but my submission is just not an appropriate use of this court's time. If we don't go back, the issue doesn't arise. If we do go back, then that can be left for the judge of the first tier. So that's what we would say about C1 and C4. As to C22, it was put by my learned friend, and I think a question raised by my Lord Justice Henderson, well, in a sense, doesn't this prove too much? Because wouldn't it mean that any alteration of a building or structure, reading land in that particular sense, would always qualify? My answer to that is twofold. Firstly, is to say, well, no, because you still have to pass the Section 11 common law threshold of being expenditure on plant or on the provision of plant, but you've also got to have an installation purpose where that installation purpose is your sole purpose. So it's not sufficient, we would respectfully say, to think that the argument necessarily proves too much. It was put by my learned friend that what we were relying on was some expansive notion of installation. We wouldn't accept that. Putting an asset in place so that it can be used, make it usable, is a perfectly acceptable notion of installation in this context. And in relation to these particular assets, the only way they are usable is if they are usable safely. They cannot be used without the provision of these safety significant structures. So we may be a rare example of an asset where the installation requires other things to be done so that the plant can be usable, but there is nothing inherently objectionable in that in the language of C22.
A sort of homely example might be just the installation of an ordinary domestic gas boiler. That itself has to comply with various safety requirements and so forth. It's not just a question of buying a piece of land on Amazon and hanging it up on the wall.
One has to connect it safely, see that there's an adequate flow. I accept all of that.
Yeah.
We are doing that on a, well, we're not doing exactly that. We're doing something very similar analytically to that on a huge scale. So it is necessarily a part of installation of these particular assets that we had to do these things, because you cannot turn the TMF on without them for fear of the near certainty of causing radiation difficulties to those around the equipment. My friend suggested somehow that because here the expenditure might have a long life, that couldn't be for an installation purpose. We say, well, that's not a requirement of the statute. It doesn't say it has to be ephemeral expenditure. There's no test to that effect. He raised again the suggestion that somehow we were running an argument that was either inconsistent with what the upper tribunal had to say in SSE, and again, so you have the clarity of that point. That is just a different debate that we recognise we were bound by practically below and here, but it's not a live issue in this case in the way that it is in SSE. My friend said, well, there isn't really an alteration of land here, because putting up a structure or a building isn't altering land. I suspect it is. If you start with a brownfield or a greenfield site and you put up a structure or a building, you are undoubtedly altering land.
In that case, this exception would apply to the erection of any building.
Look, to come back to the first counter-argument that I addressed, it still has to be expenditure that itself passes the common law test, judge-made rule, on either of the two possible limbs, and then falls foul of either Section 21 or Section 22, and has a sole installation purpose. So it's not every erection or construction of a building that would qualify. There are a series of narrowing gateways before you get there. And then the last point, or last 2 points actually, last one, when Lord Justice Henderson suggested that maybe one should think of C22 as being a relatively narrow provision, I paraphrase slightly, and wasn't it really designed to cover the digging and the concrete in Berkeley Curl, or the digging and the lining of the concrete in beach stations? But of course, C23 does say on the provision of the dry dock. And C23 is clearly designed to preserve both parts of the House of Lords decision. decision in Barclay Curl. So the digging and the concreting in Barclay Curl is protected by C23. And if I am right about C1 and C4, then the digging of the swimming pool is protected by C16, because it's on the provision of the swimming pool. Now, in that world, then C22 is doing something different. So we would respectfully not accept my Lord's observation that it can be read in that narrow sense as just being designed to reflect the Barclay Curl or the Cook and Beach Stations cases. And then the last point my own friend made was about Engineering Industries Training Board, and he rightly points to the judgment of Lord Wilberforce to the effect that installation is a word of a number of possible meanings. But his lordship in that case does clearly have in mind again putting the item in place so that it is usable. So that brings me back to the point I made a moment ago. These assets in relation to these facilities are not usable without the work that we say would fall within C22. So for the reasons I gave in opening, we believe that the First-tier Tribunal and the Upper Tribunal have not adequately addressed this contention, and they were wrong for their differing reasons to reject it. But if the logic requires it, i.e. we get to the point of needing to rely on list C, and we can't rely relevantly on C1 and C4, then we do urge upon you the conclusion that we're entitled to rely on C22. Unless there's anything else I can help you with on either of those 2 points by way of reply, those will be my submissions in reply.
Thank you very much indeed, Mr. Speaker. We're going to reserve our judgment. A draft will be circulated in the usual way with the new rubric at the top, and we may or may not need to have a further hearing in due course. Thank you all very much for your submissions.
All right.